And with that, I will call People versus Hammerlund.
Good morning, and may it please the court. Jason Eggert from the State Appellate Defender Office on behalf of Jennifer Hammerlund. Also with me at council table is our Deputy Director, Michael Middlestaff. Ms. Hammerlund's Fourth Amendment rights were violated when police officers arrived at her door and engaged in conduct specifically designed to evade the work requirement and to cause her to reach for her license, which exposed her to a warrantless arrest. The officers did this even though there was no exigency to justify their conduct, and even though Ms. Hammerlund did everything she could to demonstrate her desire to remain within the home and exercise her Fourth Amendment rights. Now, both the prosecutor's argument and the decisions below are premised on the argument that United States versus Santana controls this case. And that's simply not the case. Santana dealt with a situation where an individual was outside of their home when the officers arrived, and where the officers could rely on at least two exigencies. First, the hot pursuit exception, and also a concern about destruction of evidence. And it was under this context that they decided that she was included, Ms. Santana in that case, was in a public place. And nothing here justifies the officer's conduct either at the doorway or when they actually entered her home without a warrant, which in and of itself is a violation of taking. Now, to address this issue, we're asking the court to adopt a rule which prohibits officers from engaging in coercive or compelling or otherwise enticing conduct at a doorstep, for the sole purpose of effectuating warrantless arrest.
Counsel, what precisely was compelling or coercive about the police officer's behavior in this case? What precisely was violative of that description?
Well, sure. So what we have here is officers arriving at her home at 4 in the morning. She's then threatened with arrest immediately if she doesn't appear in the doorway. She then comes to the door, stands 10 to 15 feet back while this is occurring, and then Officer Seaman arrives at the scene, requests to see her identification, and then now we know due to an audio that we have that he lies to her that he's not trying to coax her out of the door, and then holds an ID in the doorway for the sole purpose of arresting her in the doorway without a warrant. We know that because he says, "We don't have time for your games," when he says this.
So he's returning the ID to the individual being investigated, is that right?
That's correct.
This is a half hour after the accident. It is 4 o'clock in the morning, admittedly, but the accident was 3:30 in the morning, wasn't it?
Somewhere around 3 o'clock. The exact time is not exactly clear, but around 2:33, around 3 o'clock in the morning.
I'm still trying to get a sense of what precisely was improper in the sense you use the word coercive or compelling. Are you suggesting that somehow there was something deceptive or deceitful about the fact that he was trying to return her ID to her?
Well, I think we know. First, as I mentioned before, but her whole presence at the doorway was demanded under color of office, and the officers threatened her and her roommates with arrest if she failed to appear. But also, we know that he lied to her when he said, "I'm just trying to hang her ID back," and he also lied to her when he told her, "I'm not trying to coax you to expose yourself to a warrantless arrest." And those are certainly factors that tend to show that this was a coercive or compelling, or at the very least, behavior designed to specifically evade the warrant requirement and to, quite frankly, create an exigency that otherwise didn't exist. And I think the court's recent, not so recent decision in Kentucky versus King would show a reason why officers just can't show up at somebody's home and engage in behavior designed to violate their Fourth Amendment rights.
Are we able to consider this fact about what you're calling an officer threatening the roommate? Is that evidence that came out of the evidentiary hearing, or was that later in trial?
That's evidence that came out at trial, and I would say that the court could consider that. This is a de novo review of the issue. I think the court has broad discretion to consider the facts here, and also the prosecution here submitted, obviously, a video, in name only, it's only audio, which would show that it is beyond what was, present at the trial court.
Counsel, I'm not sure why we're so focused on whether, if her arm crossed the threshold, that kind of puts her in Santana land and not Peyton land. Mm-hmm. It seems like the fact, first of all, I don't see anywhere in the evidentiary hearing transcript where that testimony is given. So it's repeatedly the officer is asked to sort of where their hands touched, and nobody tells me that they touched on one side or the other side of the threshold. It seems like the officer was avoiding answering that specific question. But putting that aside for a moment, and this might not be fair to you because we kind of asked about it, so welcome to our argument. Why isn't the second seizure, when everybody concedes that she pulled away, and he then grabs her again in the house and arrests her in the house, why isn't that just squarely within the four corners of Peyton, making the threshold risk question irrelevant?
Well, I think that it is squarely within Peyton. In order for him to enter the home, he has to have some justification for it in the form of an exigency. As I suggested in the opening, if there is any kind of exigency here at all, it's one that's a product of his own creation by engaging in this conduct at the door. Peyton, if we are to view the Fourth Amendment strict common law court principles, it is to draw from that door. He certainly crossed that with no justification to arrest him for a misdemeanor offense which he didn't even serve. So I would say that it is squarely within Peyton for that reason alone. But I think there's another problem here. With the kind of with police officers, do we want to live in a society where police officers show up at people's doors and can gain active impunity to cause an arrest? And I think there's a reason to adopt a rule to prohibit that, but I think that there is an error issue here that they did violate Peyton.
So you say the police officer shouldn't have gone to the house at all?
No, I mean officers, there's obviously reasons we want people to feel free to talk with officers. Officers can come to houses and discuss issues with people that, subject to some limitations that this court recently pointed out, obviously in the Frederick case. So it's not that we're asking this court to adopt a rule that police officers can't engage someone in public or come to the door and ask questions. But what we are asking is then, if they're coming to the door and their sole purpose is to cause somebody to leave the confines of their home, even no matter how slight, if a pinky goes out the door, you're going to get attempted to pull out, we'd ask the court to limit that type of activity. It's not that all interactions between police and individuals in the doorway would be covered.
So anytime the police try to entice somebody to leave the residence, you think that should be, illegal or unconstitutional?
Well, I think...
There's no case that holds that, is there?
Well, I don't think I articulated my answer to that correctly. And, obviously, there's going to be a lot of circumstances where a police officer says, hey, will you come outside? Or it's just a plain trick. The publisher's clearing houses here, needs to let in a police escort and come out and claim the prize. I don't think that would be something on its own that would violate the Fourth Amendment, but what we have here is something different in time.
So let's go back to Justice Markman's question. What about this interaction in terms of the officer's conduct, do you think, across the line?
I think it crosses the line when the officers here, first, as I said, given however it's considered, but they cross the line when they show up to a house and threaten her with arrest. And then she's at her doorway, and the officer is engaging in this conduct to lie to her and attempt to coax her to at least reach for an ID so he can pull her. I mean, we don't have a clear record even if he entered the house or not. That's highly problematic. And I'd say the case...
The testimony, as I understand it from the trial, is not that the officer threatened the defendant, it's that he made a statement to the roommate, that the roommate would be arrested, is that right?
Yeah. So the officers that arrived prior to Officer Taylor in the Hammerlund Police Department, and they did threaten her roommate with arrest for harboring a fugitive if Miss Hammerlund didn't come to the door, and also to arrest Miss Hammerlund.
She testified to that, what appears to me to be obvious hearsay testimony.
Well, I'm not so sure. No objection was made to that. It depends on, I think there could be an effect on the listener as to why she would come to the door to show why she did what she did. It's to appear in the doorway.
Probably double hearsay, right? Because the statement wasn't even made to her, not a court statement. But leaving that aside for the moment, should our focus be on the officer's conduct, or should it be on the conduct of the defendant?
I think it should be both. I mean, the officer's conduct here is what caused her to approach the doorway, and everything that occurred prior to her even showing up in the area around the door is significant. But also, I think her conduct is significant here. She, desire to remain within the home and stand on her Fourth Amendment rights at every point in this encounter.
So that's what's interesting. It's sort of the doorway cases that have kind of, been decided in courts all around the country after Santana and Payton. There is, as you know, they're in your brief, a series of cases where some courts say where the defendant basically presents herself voluntarily at the doorway to the police, she's basically like, it's as if she's on the sidewalk, right? And then, I know there's another issue with the 90-day misdemeanor, but putting that aside for a moment, that puts her in the, no better position than if she were out on the sidewalk when she encounters the police. But all of those cases seem to me to emphasize the voluntariness of her presenting herself to. I can't find one with a background like this where it's almost like your client went to like a Payton seminar. Do they get Payton seminars in Grand Rapids about like how to like guard your right to be in your home? How should we think about what happened before, assuming that we believe her arm crossed the threshold and that puts her into Santana land. I'm not just assume that for purposes of my question. How do we think about the background facts that led up to that, which it seems like everybody agrees were she was trying to guard her right to be in her home free of a warrantless arrest?
So this is where I think probably the Kentucky versus King comes into the equation, is that you cannot create an exigency. The Santana, as we know, it is based on this whole exigency existed right off the bat. They stop police and run into your house. That's what that case is about. But Kentucky versus King, I think, provides an exception to that kind of conduct, is when the officers, on their conduct, create an exigency which causes someone to be arrested without a warrant in their home, obviously by no fault of their own. I think it's very clear that she had every intention to remain within her home, which she had the absolute right to do. That's essentially the foundation of the Fourth Amendment. It's the sanctity of the home, being able to remain with the home unless the police officers come back with a warrant. And it doesn't, I don't think it's a fair reading of Payton to limit it as such. And I don't think the Fourth Amendment has honestly been read like that in recent times. It's not based on a strict common law court principle. We have cases like the Carpenter case that came out that don't rely on strict trespass type of doctrine. And obviously the King case is significant because officers can do things which would result in warrantless arrest.
Can I follow up on the Chief Justice's question? You use some pretty strong language when you suggest that the officer here lied, to use your phrase, or coaxed the defendant, to use your phrase. I'm not clear again what the precise nature of the officer's conduct was that either satisfied the term lie or coax. You seem to be suggesting that there was an affirmative obligation on the part of the officer to warn the suspect that, oh, by the way, if your arm extends beyond the plane of the home, you may come to regret that. We don't want you to shoot yourself in the foot by making a foolish action or a foolish statement on your part. Does a police officer have that kind of obligation to avoid the prospect that a suspect or defendant may inadvertently shoot herself in the foot, as she arguably did here?
Well, I don't think that's necessarily the case, but I do think that the police officer has an obligation to not engage in conduct specifically designed, as it was here, to cause her to put her hand in that area where he would grab her. And I think where I'm getting obviously the strong term from is from the video, where she specifically asks him, "Are you trying to coax me out of the house?" And he says, "No, I'm just making an exit report." And then when she goes to obtain the identification from him, is when he grabs her. It's obvious that he had no intention of just making an exit report. It's obvious that he was arresting her, and I think it's obvious based on his statement after the fact that I referenced before that he didn't have time to play games. He was going to arrest her by any means at that.
So can you address, assuming even that if we were to find a Payton violation, whether it be the arrest or as Justice McCormick suggests, the actual arrest inside the house, you still need to succeed in showing that the evidence should be suppressed in the New York versus Harris issue. What is your position on that, of why you, even assuming the Payton issue, that you can surmount that hurdle?
Okay, so I think there's one big distinction between the Harris case and this case, is that the officers obtained physical evidence as a result of the seizure here. And that was in the form of her blood alcohol content that was just later drawn. And that's fundamentally different in kind than a statement made after Miranda warnings at a police station. There's no holding in Harris that extends beyond close Miranda statements made after.
So do you think her statements then would still be in the police room, but just not with blood alcohol?
Well, I would say no also, and I think there's a reason for that, is that her statements that were made are different in kind than ones that are made where someone is taken from their home, driven to a police station afterwards, and then given statements. I think it's closer to the first statement that was taken in Harris, one because it's immediately after she was arrested. There's the way she was removed from the home, but secondly, she's still parked in a police car in her driveway. So she's still at least within the privilege of her home. And I think that there's, that's significant here. I think both things don't fall within Harris, but I think the clearest one that doesn't is the physical evidence of the pain. It wouldn't be the fact that if officers see somebody in their home without a warrant and then obtain drugs or a gun that they weren't supposed to have, that would just fall into the Harris exception.
Thank you, guys.
All right, thank you.
Good morning. May it please the court. Andrew Lucas from the Kane County Prosecuting Attorney's Office on behalf of the people of the state of Michigan. Opposing counsel's brief and defendant's argument in this matter is asking this court to essentially adopt the constructive entry doctrine. I'm not here to argue whether or not it is wise for this court at some point to adopt the constructive entry doctrine or some form of it, but essentially that this is not the case to do it. This is not the proper standard of review to adopt a new rule. The facts of this matter don't support adopting the constructive entry doctrine or some form of it. And even if this court were to adopt the constructive entry doctrine, this falls far below the threshold as articulated by the various lower federal courts that have adopted it. It is my argument that the defendant did not preserve this particular issue claim through the motion to suppress pretrial because that was premised on a different idea. That was premised on the idea that the officer effectuated the arrest inside the residence. And now the constructive entry doctrine is premised on the idea that the defendant is moved into public. The two separate claims, so I think it's subject to the plain error standard of review, which the defendant can't satisfy in this matter. Regardless of constructive entry doctrine or what this court has ordered us to address the compel, coerce, or entice elements, the facts don't support it. The record shows that there was no compulsion, there was no coercion, there was no enticement in this matter. Furthermore, the trial court, in its opinion and order on the motion to suppress, explicitly found that the defendant voluntarily placed herself in a public space. The trial court found that she voluntarily moved to the door and that she voluntarily moved into a public space, and that's accorded a clear error standard of review by this court. The dash cam recording, which was discovered and provided to this court a few weeks ago, the audio shows that the defendant's voice gets louder as they're interacting and making small talk about the Tigers and the relationships among the roommates and so on and so forth, implying that she's moving closer to the doorway. When Officer Stamen offers to return her identification to her, there is a 1 second that elapses between that and the tussle and the arrest is effectual. And to Chief Justice McCormick's point about whether or not there was any record evidence about whether she reached her own threshold, the motion transcript, pre-trial motion transcript, page 12, Officer Stamen testified that's when I grabbed a hold of her wrist and he was asked, and you were outside, she was inside, where was the grab taking place? He answered, I waited until her hand reached out to mine so I didn't reach in to give it to her.
That's my problem. That doesn't tell me where the connection was made. I mean, yes, they each reached in a different direction, but it's never established at the suppression hearing that her hand reached over the threshold. It may have, I don't know. I mean, I read it and I think that's possible. It's also possible that he held his hand and she reached out to meet it at the threshold or just inside the threshold. It was a little bit, it was not clearly established at the suppression hearing.
And in the follow-up testimony, what you described was, I was standing in the porch, I don't think my hand was ever inside the house when I handed her the key.
That's correct, Justice. And again, I think you're highlighting an exact problem that I raised in my brief as to why, when this issue is not specifically addressed, whether constructive entry, the exact manner in which her ID was returned to her. This wasn't an issue of the trial court, so I think that presents a problem for this court to review. It's almost as if we have a complete record here to fully address this issue of coercive ties.
But I mean, why do we care? Why isn't the fact that it seems like nobody disputes that the officer, after she pulls away from the first grab, he reaches in to grab her the second time and arrests her in the home. Nobody disputes those facts. Those seem clearer to me in the record than where their hands first met. Why isn't that just squarely within the four corners of the pavement to make the rest of this not that interesting?
Because that is exactly what was at issue in Santana. As you said earlier, Santana was kind of governing the situation.
Yeah, but in Santana, as you know, when the officers showed up, they had probable cause to believe she committed a felony, and she was in the doorway when they showed up, right? So Santana is a hot pursuit case. Are you saying this is a hot pursuit case?
I'm not saying this is a hot pursuit case. I'm saying that the court in Santana analyzed two separate ways to get to a valid arrest. They addressed whether or not she was placing herself in public. They specifically said whether or not she was exposing herself to classic elements of being in public, whether it's sight, sound, touch. She saw the officers. They were able to reach into her. The exigency analysis was after that, and it had to do when she was retreating into the home.
Right.
So I think those are the two sides of Santana, and I think they apply squarely in this case, where the defendant here reached past the threshold and then tried to retreat back into her home.
Why does Welsh preclude you from making that argument in a 90-day misdemeanor?
Because this is where it's, even though it's a statutory violation, it's not.
No. I mean, the constitutional problem of whether you can enter the home is, well, first of all, it's an open question whether the police can arrest somebody on a misdemeanor in their presence at water, let that open, right? That's an open constitutional question. But putting that aside, the exigency piece of it, isn't it precluded by Welsh? Don't you need a different theory?
Honestly, I don't agree. I honestly think that Santana controls completely. She tried to defeat the arrest upon withdrawing into her residence.
That's opportunity.
Could you just clarify the situation in terms of what precisely preceded the arm either being extended beyond the plane or not being extended beyond the plane? It's one thing for the officer to say nothing. The suggestion I'm hearing from opposing counsel is that rather than that circumstance, the circumstance here was that the officer indicated he just wanted to do something in terms of returning the identification when he had something more than that in mind. Is that an accurate rendition of what occurred here? If it is, why doesn't that make this arguably a constructive entry case?
What the officer's state of mind at what point is a little ambiguous.
I'm interested in state of mind. I'm interested in precisely what he explicitly articulated to the defendant.
He explicitly articulated to the defendant when he asked for her identification, when she's seeing 15-20 inside the residence. She stated, "Are you just trying to coax me outside?" And he said, "No, I'm just trying to write a report out." The record is clear on that. And she had the wherewithal to employ one of the other occupants of the residence to then ferry the identification over to Officer Stamos. The audio recording from the dash cam shows that she got louder. Her voice got louder. The recording declined as she approached the doorway, and in 1 second to return the identification of the rest of the class that she's seeing at the doorway.
But I'm still not getting an answer from you. What prompted that interview? What did the officer say to her in terms of what he was attempting to accomplish by having her extend her arm for him?
What prompted, he literally said, "Computer ID back." And that's, I guess I'm saying I'm not following this as a question.
My understanding of what opposing counsel said was that he indicated that that was the only purpose to be served by her extending her arm back, where he had multiple purposes that he hoped to satisfy, including apprehending her.
I mean, I think the record would show that, yes, it got presented as offered, just that the officer saying he would effectuate the arrest when she crossed the plane and was doing it in this situation. And I wouldn't say that
Did he say that he was just to return the ID?
that's what he said to her at the time. Yes, he
Why would that be misleading?
well, quite frankly, whether or not it's a misleading statement, I would say that that does not rise to the level of compulsion or coercion. When If we look at a case law that deals with compulsion or coercion, or even a plain dictionary, Black's Law Dictionary definition of words, they involve some operative force producing an involuntary response, and that's compulsion. Coercion has to do with free agency having been overmastered. We don't have that here. She used her free agency when handing him the identification and used a third party to hand over. She didn't take advantage of that exact same method the second time that she was retrieving him. She voluntarily, as the trial court found, retrieved it herself. So I think that's the distinction. That it doesn't necessarily matter whether he said he's just returning her ID to her for the purpose of maybe getting her just put her arm past the threshold. She still chose to. She was not compelled or coerced to do so. She still had a free agency. She still had free will. She could have said, "Leave on the board, I'll pick up later." I mean, that's a little bit of an absurd situation, but it's possible. She still had the free will to do so.
What the core of the Fourth Amendment, when Peyton reiterates, is the right of a person to retreat into the security of their home and there to be free from unreasonable government intrusion. In this case, the Chief Justice said that the defendant really clearly articulated her desire to stand on her Fourth Amendment rights in ways that we don't typically see in cases where she, not only physically stayed away from the door, but made other statements that either stated directly or implied that she wished to stay in the residence and not be coached out on the court. So in this exchange, would you agree it was pretty clear that she expressed her desire to stand on her Fourth Amendment rights?
Initially, yes.
What in other contexts, like when someone asks for an attorney, for example, in the Sixth Amendment context, courts have given that meaning where the law enforcement then has to stop these efforts to continue questioning, etc. What meaning should you give the fact that there was an unequivocal assertion by this defendant of her Fourth Amendment rights?
I would answer that twofold. First, she expressed an initial desire to stand on her Fourth Amendment rights. That's definite. But then she voluntarily moved to the doorway.
That either voluntarily, even when she moved to the doorway, she questioned the officer essentially along the lines of, if I do this, will I be giving up my Fourth Amendment rights? Right? That's how you can read her question. Are you trying to coax me out of the house? Answer no. With that way of saying, if I do what you're asking me to do, I don't want to give up my Fourth Amendment rights?
I think the record reflects that she stated that prior to handing her ID over, when she was standing 15, 20 feet inside the residence. That's my recollection of the record. And I think that statement was made earlier before she approached the door.
I think that's right. That's the whole point. She makes the statement, I'm not going to leave the security of my dwelling if you're just trying to coax me on the porch to arrest me.
Correct.
Answer, no, I'm not doing that. That's not what's happening. And then I'll come and take my ID back. And you're saying by doing that, she's voluntarily submitting to the arrest? I don't think anybody in this auditorium would interpret her behavior as, her holding her hands out to the officer and saying, go ahead, take me into custody. You do?
I would say that she voluntarily, by moving the door, subject herself to public space, but then I would also, second fold, to answer that question, it's a little bit analogous. Various cases have to do with interrogation. We allow officers to engage in some sort of...
But not after someone makes a demand for an attorney, right? After you say, I want a lawyer, the officer can't engage in artifice or deception at that point, can they? To trick the defendant? They can't say, well, you're really not in any trouble here. You're not going to be charged with any crime. Why don't you just keep talking to us? We don't then say it's okay.
And that's right. But the distinction is that's when you have somebody who's already in custody and is entitled to representation of counsel.
Oh, I agree. That's why I asked the question. I started this line of questioning, pointing out that this goes to the core of the Fourth Amendment, at least according to the United States Supreme Court, correct?
I would agree.
Counsel, I guess my question would be following up on my colleagues' questions. I think that judges sometimes have to look at things as it plays out in the real world. And I guess the question I would pose to you, based on the questions that you heard from Justice Markman and Justice Viviano, is going through this fact pattern, what is it the defendant should have done differently? if she wanted to protect her rights, walk through it with me and help me to understand in a real life perspective, in a real life scenario, what would she have done differently to avoid this?
Quite frankly, to avoid it, she could have avoided it in other ways. I offered the off-the-cuff example of saying officers taking leave identification on the porch. She could have stayed within the residence.
But let's go back to the beginning, if we could. Okay, first off, she wasn't in the doorway in the beginning. She was in her room, correct?
Yes, that was her testimony.
Okay, and let's just run through the scenario. Her roommate was told that, when I realized it was a hearsay issue, her roommate was told that if you don't produce this woman, you are going to be arrested for evading a crime. So I just want to take you into the real world, if we could. And ultimately, she emerged to the doorway based on that discussion, correct?
She emerged into the residence where she was visible from 15 feet from the doorway after that, yes.
Correct. So is it your argument that she should have, in a real life scenario, you have a number of police at a home, at a residence, is it your argument in a real life scenario that when you're living in a home and your roommate tells you that the police are here and if you don't come to be visible, I'm going to get arrested and I'm going to be taken in? In a real life scenario, isn't the traditional person going to feel a sense of urgency to then comply with that command?
I would agree that would create an inclination on the listener to then comply with the commands. But I would draw this court back to the facts in this particular case. She maintained that she was going to stay back in the door initially. She explicitly asked him, "You're trying to coax me outside." She had the wherewithal to know what she was possibly subjecting herself by standing in the door.
But you yourself have then said that when I asked you the question, what is it that this individual should have done? You've heard the two questions that have been posed by our colleagues. The answer that you're giving me is even you yourself have basically said that, the option that she has isn't a real tenable, correct?
My off-the-cuff example is not necessarily tenable, but she employed an option when transferring that ID to the officer that she could have used for retrieving it. She handed it to one of her compatriots and handed to the officer. She could use that exact same method as retrieving it.
So I'm not going to ask you a question, but I just want to understand something. Isn't the government's position in this case that, are you, in your fact, saying your own role? They're asking us to draw a role. But are you ultimately creating a rule that basically says that, ultimately that if you're in a situation in the heat of a moment and a law enforcement professional tells you, well, I'm not here to coach you, I'm not here to do any of these things, and you then basically trust that individual that you have heard what Justice Viviano was asking, is it your contention in a real life scenario in the heat of the moment when a professional tells you, I'm not here to coach you, here's your ID back, that if you then follow that person's word, if you then take that person's advice, you are then waiving your Fourth Amendment right? Is that the argument of the state?
I think that's the position that this court took in Dillon in 2007, where the defendant in that situation has a apartment surrounded by law enforcement, both uniformed and ununiformed. They were telling him repeatedly, if you step outside, nothing will happen, it'll be fine. He was on a tether, he was worried about setting off his tether. And then he stepped outside and was immediately arrested.
Let me just ask one last question. Do you, from the government perspective, have concern that if we adopt the rule that you're asking us to adopt, that that's going to create a certain level of distrust amongst the public for these types of interactions?
I should simply be clear, I'm not asking this court to adopt any rule, I'm asking this court to not adopt the rule in this case.
Okay, fair enough. But by going with your argument, do you have concern if we follow your argument that basically that will create a heightened distrust of law enforcement?
And I would say we already have that rule in place already. This court already had addressed various situations where they felt that law enforcement can't engage in some sort of cajoling and luring. That's fine, as long as it's not subverting somebody's will to act against their interests.
And is that the message that you think is a really good message to kind of share with high school? I mean, do you understand the concern that I have? Do you see the concern that I kind of have with this? Is that people want to be able to trust and engage?
I I do,
And
Your
it
Honor.
needs to be done.
Whoa, whoa.
There's
Oh my God.
kind of a respect on both sides, but most importantly, people have to know that the game is fair. And that's also good for law enforcement. Law enforcement doesn't want to be in a position, as you admit, in a situation where they're interacting with the public, and the public is concerned about basically taking their orders.
And Your Honor, I think the point is well taken. I'm simply arguing what I think the law is and what the law should not be in this case, regardless of who my audience is and actually the community.
Thank you, Counsel.
You use the white pen, but Justice Hart has a question for you, so please come in. Not you. You're good. Thank you. Thank you. That's great.
Would you guys not post it in this case with defendant? Are you trying to coax me outside? Officer standing. No, I want to see your ID so I can make an exit report. After that, is it your position the defendant could have freely walked out on the front porch and not been subject to arrest?
Well, I think, but the basic answer to that is, if she walks out, that's a different story. Again, someone, I think it's clear based on what is standing on their Fourth Amendment rights. They're attempting to remain within the home. Both of them are still planted inside of their house.
So it's a question of whether her feet come outside as opposed to her hand?
Well, I think there's a difference.
In terms of how we look at this, she's, in our case, has maintained a desire to remain within the home, and that's clear. A person that just walks out their front door maybe might not be doing
She
it.
made this representation. Are you trying to coax me out? You know, she says, no, I'm not. And so then after that, she extends her hand out the door, he grabs it. You're saying that's a foul. If instead of just extending her hand, she would have walked out on the porch, would that still be a foul?
Well, yes, I think it would, in a case that's addressed that, albeit in kind of a short way, would be the Boykin case. It's kind of similar where they deal with almost a one way or another type of thing, where the officers aren't coming up with guns drawn like we see more. And I think that would be a problem with respect to, if all facts are the same and she just steps out to grab it, I think, yes, that's still a problem. And I think part of that is the identification.
So he doesn't extend, if he doesn't, are you trying to coax me? No, I'm not. And he takes the ID through the third party and he's writing his report. And then she steps out, he can make the arrest.
I would say no. Obviously, our case is a little clearer where she's not stepping out.
I understand, but I have a rule that applies across the board.
I think in cases that have adopted a constructive entry, I didn't see one where someone stayed in the home as much as they did here, but when people would then step out in response to police officers' conduct, that was still held to be constructive entry. And I think there's a significant point here is that the officer's just not holding anything. He's holding her driver's license, which in a lot of Fourth Amendment jurisprudence is significant. Several courts tell that when an officer's holding an ID, at least in a public setting, they don't feel free to leave. They're being seized. And that's a very significant inquiry here. It's not what he is holding. It is important to that analysis. So I think that her stepping out in a constructive entry context is completely still consistent with applying the doctrine, and several courts have applied it that way, where people have walked out in response to threats and coercion or the type of